Now, I'm going to tell you how you can beat debt collector lawsuits. I beat debt collectors when I was going through my financial situation in the 1990s, and I'm going to tell you exactly what you need to do to be able to stop these debt collector lawsuits. Debt collectors have been suing more than 4.5 million people across these United States with debt collection lawsuits from debt that they purchased from original creditors, and most of the time they lack the proper documentation to even bring the case. So what I'm going to do is I'm going to share with you the information that I've learned by putting into action the steps to beat debt collector lawsuits when they file these cases in court. The first thing that you need to be aware of is that you are going to be served by the debt collector. They're going to, hire a process server, or they're going to do attempted service. You need to look at your state laws, because in some states they allow you to be able to allow the debt collector to be able to proceed with the case if they just prove service. Now, these are the ways that they get away with proving service. They can attempt to serve you even if you don't sign it. They can leave it at your doorstep. In some states, that's what they could do. In some states, they can attempt to serve you in person. If you don't answer or won't answer the door or won't take the paperwork, they can mail it to you, and they'll write in there. You'll see this. They'll say that it was this person, they'll black hair, 5 feet, 10 inches tall. They'll describe you in there, that if they believe that you're the individual because they got data points of the address where you work at, whatever, they'll believe that you're that individual. They'll state that in their attempted service. The other thing that they'll do is they'll publish your name saying that they're trying to serve you for a lawsuit. They can do this online, do it in local newspapers if you still have a local newspaper in your area, or a weekly newspaper. So all they have to do is attempt service. In some states, they do have to actually serve you, or they have to take additional steps that they actually tried to serve you. So look at your state laws on that, because if they could do attempted service and get away with that, they could proceed with the case. And because you didn't get served, you are thinking that the case can't proceed, and then all of a sudden you get a default judgment, and now you, instead of just being able to respond to the initial summons, you have to actually get that default judgment overturned. Don't worry, we can help you with that. So once you receive that summons, that's going to bring up a whole bunch of anxiety, more than it was before, when they were just trying to attempt to serve you, because you know how we are as humans. Until we actually get to see it, some of the times we just fear it, but we really, really fear knowing what's going on. Like, something's going on, so you have fear and anxiety, and then when they give it to you, the fear and anxiety level jumps up, like way up. I know this because it happened to me. It happened. So I'm in your court. I've been where you are at right now, so I know what you're feeling. But we gotta get through it. We gotta get through it. So we're gonna get those documents. Once we get those documents, we're gonna know what we're dealing with on those documents. And I got one right here in front of me that was sent to me today. It's gonna have the complaint, and it's gonna have all of the allegations. It's gonna be like 1, 2, 3, 4, 5, 6, depending on how much detail they're gonna want to go into. They're gonna state the allegation against you. You got to answer all of those. You got to answer all of those, or you can lose your case, depending on the judge that you get in front of. But I can tell you 99.9% of the judges, if you do not answer that summons, those allegations in the summons, you're already, in trouble, because this is what is required by the court. They don't just write this up for you to just disregard it. So depending on how many allegations they want to put in there, you have to take the time to answer all of those. But don't worry, I'm going to help you out with that. I'm just telling you right now, letting you know what you're required to do. Some of the things that they're going to have inside of those allegations, they're going to say that who's suing you. They're going to say that this is the company or the debt collector that is suing you. They're going to say that either they maybe were assigned the debt. They're going to have the amount of the debt. They're going to have the last four digits of the account number. They're going to state things in there such as that you breached the contract. They're going to state things in there such as you have unjust enrichment to make you look bad. That's why they're going to have those things in there. And they're going to state in the end, in closing, they're going to say that they want to get a judgment, and they're going to have the full amount, and they may throw in the court cost and any other relief that the judge seems to deem appropriate. And then they're going to sign off with it, and they're going to have the attorney who brought the case against you, and then they're going to probably put some documents, maybe the contract, maybe they're going to put a bill of sale from where they purchased the debt from, and some statements. And that's what they're going to put in a cover letter. That's what they're going to have in there. You're required to answer to all of that. So now you're probably thinking, okay, Steve, what do I need to do? I don't know anything about this stuff. I need to take care of my family. I don't want them garnishing my wages. I don't want them going into my bank account. I don't want them taking assets. I need to know what I need to do. And why should I even listen to you on this? Well, the first reason why you need to listen to me on this is because I've went through this stuff myself. And what you should either feel from me, from the way I'm talking to you, is that someone who has went through it knows exactly what you got to do from day one. And that's what I'm talking about in this video. From day one is you got to go ahead and get that summons, and you got to go ahead and review it, and you got to calm yourself down as much as you can. Try to do your best to get the emotions out of it and put together a concrete plan to deal with this. So the concrete plan to deal with this is to answer all of those allegations against you. Some of those might be definite truths. Some of those you may not be able to answer. And you do not have a duty to make their case for them. So you don't have to answer anything that you believe that they should already have 100% in their hand that they know. You don't have to answer it to admit to it. The next thing that you got to do, and you need to craft this, is you need to put an affirmative defense to win your case, to defend yourself in the case. And the best way to do that is to review the case against you, review the documents that they've submitted, and then you put together your affirmative defense to actually beat the case that they've brought forward to you. Now, let me give you a little bit of a golden nugget that a new client, when I reviewed their document, and they tried to do this stuff themselves, and then they came to us to get some help, is they said that they had I guess they had watched another person's video, and they put together their response. And in their response, they did not put a defense to defend themselves in the case. So this is very important, because you could answer the allegations against you, but if you don't put forth any defense, you're going to lose the case because you didn't defend yourself. Just think about it logically. With any case, no matter what it is, civil, whatever it is, what is the number one thing that you got to do? You got to defend yourself. But you can't defend yourself with words. You have to defend yourself with words on that document, on that response. So what you do is you're going to put together your response to all of the allegations, and then you're going to craft yourself an affirmative defense to beat the case that is put forth against you. Part of the case that's put forth against you is going to be with documents. Some of it is going to be just with words that they, allegations with their words with no supporting documents. And then there's going to be some documents that they probably put together from the purchase of the contract. There's going to be some documents showing the conformity. There's going to be some documents making sure that you're not a veteran, active duty military individual. So once you get all of those documents and you review everything that they put against you, you're going to put your response to their allegations. You're going to put your affirmative defense to the best of your ability to be able to answer and put together an affirmative defense to beat their case. And if you do that properly, you're going to be able to win your case in most instances. Now, there's no guarantees, but that's going to put you in the best position to win your case. Now, some of the questions that have been asked to me of should you try to do arbitration and all of that. If you watched any of my videos, I say absolutely not. If you push to go to arbitration, more than likely, if you want to pursue arbitration, they're going to make you pay a fee. Some of the times they're going to make them pay a fee, but if you pursue it as the individual that's getting sued, all you're going to be doing is putting yourself into a situation to start a negotiation process. Why would you push yourself to go into a negotiation process when you actually have a defense to potentially win your case, and you end up paying nothing but what it took for you to get your response put together to perhaps win your case? So don't trap yourself that way with doing that, because even if you lose your case, you'll have an opportunity to negotiate a settlement. So why force arbitration when you're going to have an opportunity to negotiate in the end? I know the reasons why people pursue arbitration, because they have this mindset of if it's going to cost them this certain amount to go to arbitration, they're going to just say no. Well, you're going to see that that's not going to be the answer, but if you want to pursue it that way, you'll see that. Because I have plenty of people who come to me who thought that, and all of a sudden they were like, I just went right into negotiation. I didn't even have an opportunity to defend myself in the case once I went into arbitration. So in my opinion, not giving you legal advice, but in my opinion, you want to avoid that. You want to make the whole fight against the debt collector attorney who is suing you, the whole case against them, your whole defense against them is against their documents and against lack of documents and against what they are required to do when they're bringing these cases. Now, if you are being sued by a third-party debt collector or original creditor, what I want you to do is I want you to go to summonsmaster.com. You can upload your summons in a PDF form, has to be in PDF form, and it'll create a response as if you were dealing straight with me. I trained this. You can't get this on ChatGPT or anywhere. If you're not good with documents and you want us to do it for you, we can put together the documents and and get it your response submitted to you. You can go to thecreditrepairshop.com and you'll see where we had that service available in the Credit Repair Shop also. If you are being sued, do not delay. You have a certain amount of time to respond to debt collector lawsuits. So don't be paralyzed. Don't think that it's going to go away. This stuff is getting very serious. As a matter of fact, some of the debt collectors, due to the power that the power that was taken away from the CFPB, these debt collectors have gotten emboldened in the way that they're going after people. But you still have the courts in your favor if you put together your response the right way. So thank you for your time. This is Stephen A. Williams, president and founder of thecreditrepairshop.com and summonsmaster.com. If you need help with your credit, please visit thecreditrepairshop.com. Watch video What Makes It Different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. If you have debt collectors coming after you early in the game, you can go to Summons Master to get your exclusive certified debt validation letter created for you. All you have to do is sign and date it, or you can grab my 3-pack of letters and you can do everything yourself. Links are below this video. Thank you for your time. This is Stephen A. Williams, president and founder of thecreditrepairshop.com. Subscribe and post your questions and comments.